So I have a couple questions.
No, well, hold on. You don't get to ask questions. I'm going to ask the questions. Mr. Gomez.
Lupe Gomez repeatedly denied his identity and used confusing third-party intervenor arguments to disrupt the hearing. The judge stayed firm, controlled the courtroom, and made it clear only she would ask questions while focusing strictly on the facts. Meanwhile, the prosecution failed to bring their key witness, leaving no evidence to present. In the end, the judge granted the motion to suppress and dismiss the case, leading to Gomez's release.
All right, 23 DCCR 0319 on Lupe Gomez. I've got Mr. Nichols here for the state. Mr. Radford is here. Sir, you, Lupe Gomez.
I'm sorry?
Is your name Lupe Gomez?
I've been on for
What?
third-party intervener, cross plaintiff, superior lien holder, to appear by special restricted visitation and not by general appearance.
Can you do this? Can you come around and have them so I can see better?
You want us off the bench, John?
Yeah, y'all can all come up here. Okay.
So I have a couple questions.
No, well, hold on. You don't get to ask questions. I'm going to ask the questions. Mr. Gomez.
Can happen until all parties are identified into the record.
All right. So, Mr. Tell me again who you are. Who are you saying
I'm
you
a
are?
non-corporate third-party intervener here by special restricted visitation and not by general appearance, under duress by the means of threat, coercion, and kidnapping.
Okay. Have you ever been known by the name of, in the past, Lupe Gomez?
Will you state your name for the record, please? And will you order the prosecutor to state his name for the record? And do either one of you have a claim against me?
We do have a claim against you. My name is Raquel West. I'm the judge of the 252nd District Court. This is Mr. Luke Nichols. He's one of the assistant district attorneys in my court. Mr. Radford is here representing you.
Okay.
There's an indictment. There's a motion to quash. Mr. Radford has filed that we're here for today. I'm going to take judicial notice of the court's file, which includes numerous documents, including a indictment, the probable cause affidavit, other identifying information that does identify you as Mr. Lupe Gomez. And I'm going to make the finding at this time that you are, for purposes of this hearing, Lupe Florencio Gomez. And we're going to go forward with the motion to quash. Mr.
What's a motion to suppress?
Motion to suppress. I'm sorry. Let me get that pulled up. I have a motion to quash as well, correct?
Yeah, you do.
Hold on.
I think that's a pro se motion.
Okay, so we're here on Mr. Radford's motion to suppress. Let me find that one. It's okay. I'm looking.
Well, while you're doing that,
Nope, stop talking.
To the record,
Stop talking.
Your foreign agents and registration statement.
My what?
Are you refusing to do so?
I am.
Okay.
Here we go. All right, so Mr. Radford filed, it's entitled motion to quash and or suppress evidence.
Oh, okay.
And that's why I was confused because it just showed the first part. And 23 DCCR 0319, this was filed April 29th of 2024. And Mr. Nichols, you may call your first witness with regard to the suppression.
State calls Officer Chad Morrison.
Would you please call the name?
Officer Chad Morrison. No response, Your Honor.
All right, Mr. Nichols.
Your Honor, I have no other witnesses in this time for this hearing. The state rests. May I make a statement on the record?
Yes, you may.
Your Honor, I was in contact with Officer Morrison last week. He is formerly of Port Arthur Police Department. He now is with a different agency in the greater Houston area. He indicated he is on injury leave at the moment and would not be appearing for this hearing. He was also on injury leave and was unable to appear last time we were set for this hearing, approximately 2 months ago, maybe in May. So that at this point, the state has no other option but to rest in this hearing and present no other evidence.
All right. Anything, Mr. Radford?
No, ma'am.
Well, based on that, then unfortunately, I have no choice at this point, which is unfortunate that the officer won't comply with showing up, but I'm going to grant the motion to suppress evidence in the case. based on the fact that there's no evidence today presented. Is there anything else, Mr. Radford?
Would ask that the court dismiss the case, but I think Mr. Nichols is already preparing that.
I'll tender dismissal of the court, Your Honor.
All right, Mr. Gomez, I have granted Mr. Radford's motion to suppress because the officer didn't show up. What that means is there's obviously no evidence that would be able to be presented in your case. Mr. Nichols, it looks like, is going to present a dismissal based on the fact that there won't be any evidence, and I'm going to sign that. Your case will be dismissed.
Okay.
You can go back with the
One more
bailiff.
question. The bond money, being that the case has been dismissed, the bond money needs to be returned.
Did you pay a cash
I paid
bond?
cash, $5,000.
But you're back in custody.
You're right. But I still paid. The case is this.
Yeah, that you can take that up with the district clerk once you're released. All right.
Another reminder that courtroom control always belongs to the judge, no matter how someone tries to challenge it. And sometimes cases don't fall apart because of arguments, but because one side simply isn't prepared. If you've seen situations like this before, drop your thoughts in the comments. If this gave you a clearer look at how quickly things can turn in court, leave a like and share it with someone who'd find this interesting.